Worship, we all know that the system that is applicable in the Republic of South Africa, insofar as Schedule 5 bail applications are concerned, is for the court to exercise its judicial discretion correctly, and in that process to order the detention of an accused person, and the court should allow the accused person to present evidence that would satisfy the interest of justice so that the accused can be released on bail. This task, Your Worship, is not given to the NPA. This task is not even given to the NPA, but to the court to exercise its discretion. And it's in common cause that the bail application that we faced with herein falls within the ambit of Schedule 5. And I submit that so because of the accused has a previous conviction of stock theft that occurred more than 16 years ago. This bail application, therefore, has to be considered in terms of Section 60, 11B of the Criminal Procedure Act 51 of 1977 as amended. And it's my submission, Your Worship, that Section 60, 11C does not apply to this bail application. And according to this section, Your Worship, Section 6011, when accused has been charged with an offense referred to in Schedule 5, the test is lower as compared to what the charge would be in Schedule 6. Now, in this matter, Your Worship, what happened is that the accused is facing 3 counts of fraud, 2 counts of violation of a body, the 2 counts of contravention of PRECA, arson, contravention of Section 115 of Act 111 of 1998, and defeating the ends of justice. During the hearing of the bail application, the legal representative on behalf of the accused, being myself, read the applicant's affidavit duly commissioned into the records, and that was marked as an Exhibit C1 by the Honorable Learned Magistrate. The state, in rebuttal, then called an investigating officer, Lieutenant Colonel Flyman, who testified under oath, informing the court about his attitude towards the bail, personal circumstances of the appellant, or the applicant, I beg my pardon, and the role each applicant played in the commission of charges preferred. He indicated and confirmed to the court that the applicant is staying in Bloemfontein in the house that is on his name. He resides there with his wife, whom he recently married just before the escape, with 4 children. The accused says in his affidavit that he's staying with 7 children in that particular house. He confirmed, Your Worship, that the accused indeed has assets, among others cows, that he would buy and sell. He said the accused is unemployed. He was dismissed at work, and only under cross-examination he said that he was told that in actual fact the accused has been dismissed. It's my submission, Your Worship, that this cannot be correct, seeing that the accused was on leave on the day he was arrested. That's the 11th of April, 2023, meaning he is still employed at this institution where he is working. He confirmed that the accused has no passport, has no pending cases against him, except this stock theft that I have already referred to. He says in his evidence, the accused wanted to speak and call the police officer who, for one reason or the other, happened to be one of the investigating officers as they investigate this matter in a team. And they met at the local mall called Mimosa, and that is where the accused was arrested, or where the arrest took place. The version of the accused, insofar as this matter is concerned, contradicts what the investigating officer said. The applicant says he was called by the police to meet them at the said mall. Therefore, it is incorrect to say he's the one who called the police. If the version of the IO is then correct on this issue, he is not in a position to can explain how the applicant would have got hold of these numbers or would have known the numbers of this investigating official. It's common cause, Your Worship, that it doesn't need an intelligence of a scientist to know that it's very difficult to obtain the telephone numbers of any SAPS member at the local office. It will even be more harder to obtain the telephone numbers of a person working by the Hawks. It's my submission that the IO knows it himself, that he was wrong in this regard to say that the accused is the one who called the police. And I'm going to request this court to accept the version of the accused as being probable. We're not going to lose sight of the fact that the IO admitted that it is human to err. Your Worship, it's not in dispute that was contained in the affidavit of the accused or the applicant in this matter. It's correct. He doesn't have enough blankets at the detention center, which is in Sosselbeck. And as a result, he contracted flu. No relevant treatment or medication to dispense, as the accused indicated. It's also not in dispute, as per the affidavit, that being in custody would impair his ability to properly prepare and instruct his legal representative, as he will not be in a position to go and consult possible witnesses he might have and present them to the legal representative for consultation in order to prepare his defense. And this is not rebutted in any form in evidence from the state. Your Worship, I just want to add on this that the accused is detained in Sosselbeck. It's quite a distance from Bloemfontein to drive to Sosselbeck. He is indigent, and that is why Legal Aid came on board for his assist. Legal Aid South Africa came on board to assist him in this regard. And unfortunately, Legal Aid doesn't have those resources to can commit between Bloemfontein and Sosselbeck if this court is going to deny the applicant in this matter bail. It's also common cause, Your Worship, that the applicant is unlikely to evade his trial. It has been cleared on his affidavit He has not made any threats to any person. The applicant doesn't know the witnesses against him in this matter. And just a reminder, Your Worship, that the accused is not employed by G4S or even the Department of Correctional Services like everyone else employed at that institution. He is employed by the private company called Tegriton Security. The applicant indicated that should he be released on bail, he will stand his trial and attend all court appearances as he wishes to prove his innocence in this matter. It's also not in dispute that from the investigating officer's testimony, he still needs a month or two to complete his investigations. The applicant has already spent 6 weeks, is on his 7th week now in custody, and the investigations are still not yet complete. We do not know at this stage, Your Worship, what is still outstanding, except to be told that other people still has to be arrested. I'm going to submit the following, Your Worship, as the reasons for the state to oppose bail on behalf of Dipolo James Teboho, as outlined by the investigating officer in this matter. He said the following: the administration of justice will be undermined if the applicant is released on bail. He further said, there's a high-profile matter that was even discussed in Parliament of the Republic of South Africa. The community is outraged as they feel or they harbor a feeling that the police are not doing their work. And he further said that applicant 2 in this matter is fearing for his life against his co-accused. Your Worship, we're dealing with a Schedule 5 bail application herein. It's expected from the accused to prove on a balance of probabilities that the interest of justice permits his release on bail. And in a bail application, there are factors that the court has to consider that are enumerated in Section 60, 4A to E of the Criminal Procedure Act 51 of 1977 as amended. These factors that are to be dealt with in finding the likelihood of the grounds set out in Section 60 are read with factors set out in Section 65, 6, 7, 8A of the Criminal Procedure Act. Now, Your Worship, before we could even look into these factors, I think it would be proper to set out what the learned judge in the matter of Kula versus the state delivered on the 4th of April 2023 in the Northwest Division. The citation, Your Worship, is Kula versus state, open bracket, CAB 02/2023, AN WHC 35. The learned judge, Peterson, said, Section 35, 1F of the Constitution of the Republic of South Africa acknowledges that persons may be arrested and detained for allegedly having committed offenses, but such arrestees are entitled to be released on bail on reasonable conditions should the interest of justice permit. Now, deciding whether the interest of justice permits such release and determining appropriate conditions is an exercise that needs to be performed judicially in accordance with the procedure laid down in the Criminal Procedure Act. It's common cause, Your Worship, that the personal circumstances of the applicant were not placed seriously in issue by the investigating officer, and it is therefore clear that this court should find that in favor of the applicant that he should actually be released on bail. I now tend to deal with these factors that are on 4A, 4A2E. The interest of justice do not permit the release from detention if the release will endanger safety of the public or any particular person, or will commit a Schedule 1 offense. There's absolutely no evidence put before this court that would suggest that the accused, if released on bail, will commit a Schedule 1 offense. Where there is a likelihood that the accused, if released on bail, will attempt to evade his or her trial, very clear before this court that the accused is rooted here in Bloemfontein. The accused has no passport. Accused has no relatives out of the boundaries of the Republic of South Africa. It's a clear indication that based on that, the accused will stand his trial. Is there any likelihood that the accused, if released on bail, he will attempt to influence or intimidate witnesses or to conceal or destroy the evidence? It's also my submission, insofar as this is concerned, that witnesses are unknown to applicant 2 in this matter, unless a list of such witnesses is served upon him. But as at this time, when we busy with this bail application, no witnesses are actually known to the applicant. By the way, Your Worship, we're not going to lose sight of the fact that no hearing was held for applicant 2 in this matter. And it cannot even be said that people who testified against him in that disciplinary hearing are potential witnesses in this matter. That assertion does not hold. It's not here. It's not going to help us in any way, because there was absolutely no hearing for the applicant at Tegregon Securities. Whether there's a likelihood that the accused, if it's released, will undermine or jeopardize the objective or the proper functioning of the criminal justice system, including bail system. Your Worship, there is before I just come into the issue of a higher test in 4E, we're told that there is a group of people who are against the release of the accused, and they are the supporters of one team called, or used to be called, Celtics. And as my learned colleague put forth a question to the investigating officer, it was said that this is a handful of people who are less than 50 at any given time. Your Worship, I want to submit that This is one issue that was canvassed also with the investigating officer, that there's a group of people that want justice for one late Bereng. And unfortunately, my take, or one I conveyed to the investigating officer on that particular day, was that they are of the view that the accused before this court, and now I refer now specifically to accused number 3, applicant number 2, took part in the demise of the late Bereng. It is unfortunate, Your Worship, that accused 3 is not facing any charges of murder, and this has not been correctly conveyed to the Celtic supporters to understand what this is all about. Now let's move over to a higher test of 4E in this matter, where there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Your Worship, it's my submission that in this matter, accused 2 is already released on a bail of 10,000 rand. And nothing has happened ever since. He was released into the very same community, facing charges similar to what these accused persons are facing, released into the community, nothing has happened. And I do not think that the court would want to separate the issues here, that because accused 2 stays out of the jurisdiction of this area, therefore the people that are within the jurisdiction of this area are not entitled to be released on bail. I do not think that is the direction that this court would really want to take. There's never been unrest since this second accused was released. This matter has been in the public domain, as I argued, as I took it over with the investigating officer more than a year ago, and nothing has happened. He says this matter got into the public domain as early as March this year, this calendar year. And Your Worship, we all know that this matter has been in the public domain from what Judge Cameron said when he handed it over to Ground Up to investigate in September 2022. And nothing. The accused have been staying at his place. Nothing has happened. And Worship, what I'm saying is, as my learned colleague has said, what is required is a likelihood of undermining the public peace and disturbing the public order, not a mere possibility. If this court is going to look into the factors that are presented before it, the magistrate may also impose a suitable condition to deal with that matter. Whether there will be an outcry as the investigating officer testified before this court, we are also told that there are factors that the court has to consider. Whether the nature of the offense or the circumstances under which the offense was committed is likely to induce shock or outrage, whether the safety of the accused might be jeopardized by his release, whether the release of the accused will undermine or jeopardize the public confidence in the criminal system. Your Worship, this matter has been settled in the matter that my colleague has already outlined before this court, in the matter of State versus Dlamini, 1999, 2 SACR 51 CC, where the learned Judge Krichler said, it is important to note that subsection 4E expressly postulates that it is come to play only in exceptional circumstances, which I've already said that it's of a higher case. There's a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it is really justified. What is more, subsection 4E also expressly stipulates that a finding of such circumstances has to be established on a preponderance of probabilities. Lastly, once the existence of such circumstances has been established, paragraph E must still be weighed against the considerations enumerated in subsection 9 before a decision has been made. My learned colleague has already referred to what are those factors that the court should consider dealing with subsection 9 of this Criminal Procedure Act. The judicial officer will therefore rely on this ground with great circumspection in the knowledge that the Constitution protects the liberty interests of all. Close quotes. The magistrate cannot be influenced by the events which manifest themselves on the media, comments on Twitter, and protesters who gathered before the court opposing the release of the accused on bail. The magistrate has to deal with the issue of public outrage, not just pay a lip service to the statutory provisions and apply the provisions of section 69 to mitigate on this aspect of people gathering in order to oppose bail.
Sorry, Mr. Magama. Section 69 or
60 subsection 9. 69. Their submission that there was no outcry based on what we currently have here. Accused 2, as I indicated, Your Worship, was released on bail and no evidence was submitted to rebut except the information that we've been given by the investigating officer in this regard to say the community is outraged. These other factors, Your Worship, were also dealt with in the matter of State versus Smafe. The court, I'll just get the citation for the court on this one. The court at paragraph 112 clearly stated, would you recall, Your Worship, that we were told that the accused made some pointing out, covering his head because he was fearing for his life. He was scared of the co-workers. We're told that. We're also told that in one or the other, the accused sort of confessed to the commission of this offense. At paragraph 112 of State versus Maffe, the court relied for the refusal of bail, relied heavily on the pointing outs or what the accused said to the police upon his arrest, which was a confession. It's tried law that bail proceedings on their own nature are sui generis and concerned with the liberty of an individual. There's a right which is enshrined in the Constitution. Our courts, in similar cases, have said that admissibility of pointing outs and purported confessions made by the applicant at this stage is not an issue to be determined by the bail court. It's an issue that is best left to the trial court to consider after all evidence will be tendered before it and a proper determination has been made. At this stage, Your Worship, we don't know as to what were the circumstances of the pointing out, if ever they were made, and the purported confession, if any. We do not know. But as I say that, there's a matter for the trial court. In that very same matter of State versus Maffe, the court went further to say, in addition, the accused person cannot be kept in custody pending his trial as a form of punishment. We're not going to lose sight of the fact that these type of matters take long to investigate and to finalize. As we are already aware, the investigating officer said that he needed a month or two to complete his investigation. It's not yet clear what's outstanding. It's not yet clear how many people are still to be arrested. But the fact that there is still a possibility of investigation going on, that means that the accused may be kept in custody for the longest time ever, pending the investigation. The investigating officer went further to say that the people are saying the police are not doing their work. That's one other reason we request this court to refuse bail on behalf of the accused persons. Now, one wonders, Your Worship, as to whether the accused should be kept in custody as a form of punishment to adhere to what the investigating officer requested, or to prove a point that they are actually doing their work. And the response thereto, Your Worship, is a no. And as I'm saying that this matter was also canvassed and dealt with, seen to be unconstitutional, and was confirmed in the matter of State versus Bennett, 1976, 3 SA 652 at page 655. The court said, detaining an accused person for purposes of investigation and consequently in so doing will frustrate the applicant's constitutional right to be detained without lawful and just cause. Generally, courts grant bail to an accused person unless there's a likelihood to prejudice the ends of justice. We all know that this matter was also confirmed in the Constitutional Court, where an observation was made that the interest of justice is to grant bail to focus primarily on securing the attendance of the accused at trial and on preventing the accused from interfering with the proper investigation and prosecution of the case. I've already dealt with these issues. Your Worship, the court must also consider the fact that the accused handed himself over to the police, cooperated with them. He still intends to cooperate in whatever manner that he would be required to do so. It's therefore my submission, Your Worship, that there is no evidence placed before this court that the accused will become a fugitive should he be granted bail. The accused has no pending cases against him, except this one that's keeping him in custody for a period of more than 7 weeks already. No outstanding warrants against him. He has this previous conviction of 2017. No passport. No evidence before this court that an accused person is a violent person. It cannot be disputed, therefore, that the witnesses are also unknown to him. It's my submission, Your Worship, that the accused or the applicant made submissions before this honorable court that complied with and satisfied the requirements of Section 60(11)(b) of the Criminal Procedure Act and is therefore entitled to be released on bail. Your Worship, I just want to deal with one aspect that was posed to my learned colleague, that the accused, when they are here in custody, they are being monitored. Your Worship, I just don't understand how would this court say that is a fact on its own. Yes, we all know that they are being monitored when they're before the court. But if the accused...
No, sorry to interject. The court meant to say, as a matter of fact, as per evidence before me.
Yes.
Yes, not the truthfulness of what was said.
That's correct, Your Worship. The evidence before this court, I do not think that that evidence should be taken as the truth, as a fact, because the accused are also saying, insofar as that is concerned, that they have no issues with each other. This is something that weighs heavily against the version that says they are being guarded herein.
But is that piece of evidence before me?
Your Worship, Your Worship, I'm saying this is what if the court can look into the affidavit. If the accused denies allegations leveled against him, in a nutshell, he means these are some of the issues that he will deny. I'm not saying that the evidence of them is specifically before this court, but I'm making an inference from what is already before the court.
But it is expected from you to address me on the evidence that is...
Fully agreed. I fully agree, Your Worship. Yes, but I'm saying...
And I cannot, draw inference on the aspect that you are drawing me to. Because when you say you meant, or it was meant to say in respect of whatever that may be said against them, they will deny it. My understanding was that allegations as per the charges preferred against them.
Fully agree with the court on this aspect, Your Worship. I'm not going to take it any further, but what I'm saying to the court is that, Your Worship, by stating the fact that they are denying, especially accused 3, he is denying such averments in his affidavit, it then means that it has a bearing on that piece of evidence that is before this court. Yes, Your Worship. As I indicated, you get that marker net. The get this well. This doesn't give me the perfect citation, Your Worship, but this is a matter that was held in the High Court of South Africa, Western Cape Division, case number A49/22, and is a Western Cape Division. This matter, the judgment was delivered on the 31st of May 2022. As if there is any other aspect that this court would like to hear me upon, it's my submission, as I indicated before, Your Worship, that the accused is entitled to be released on bail as he has satisfied the requirements of the said section.
Reference that you have just made, it is in relation to State versus Mafia?
State versus Mafia, yes.
Right, I heard when you make your submissions that the applicant is suffering from impecuniosity.
From?
From impecuniosity. You said he is indigent.
Yes, yes.
I do see, according to his affidavit, he offered a bail of 500 rands, rather 5,000 rands.
Correct, correct, yes.
Amount of bail that is far beyond than the bail money that is offered by other co-applicants. I just want to check, if you say he is indigent, how possible is making such a huge amount of money?
Well, Your Worship, I'm not aware of what other applicants said or offered. But you'd recall that the investigating officer himself testified before this court that the accused is left with 3 cows and he conducts the buy and sale of the cattle. In this 3 that is left, in order for them to make that available, they had to sell a cow. So, meaning at this stage they're left with 2. So that's the kind of business that he is currently doing. Because as we indicated that the last time that he was employed, it's on the 10th of April 2023, and since then he has never got any salary whatsoever. So that's basically how he's making his living.
Okay, I just want to be sure, did I hear you correctly? When you concluded, you said applicant does not know the witnesses.
That's correct, that's correct. He doesn't know the potential witnesses, people who may come and testify. Yeah, he doesn't know them, they are unknown to him.
But how do you then address the contradiction as per what you are submitting before me with paragraph 6.4 of Exhibit C1? I have a latitude to
What is it? 6.4?
Yes.
No, Your Worship, I think it's a issue on my part to say that if you read this in context, it says, I respectfully submit that I have also not made any threat of any sort and any nature to any person involved in this matter against me. I also do not, actually should have read, do not know.
Yeah, but before me, it was read like that. It is not saying do not. And that is how I understood it. Even if I read in context of what you have already submitted, it does make sense in that fashion.
Yeah, but Your Worship, clearly, this is very clear. It goes even further to say that as such, undertake not to contact or attempt to contact any of the state witnesses.
Despite knowing them, I don't have that intention to contact them.
Yes, no. If this has to be read in context, the entire paragraph has to be read in context. You're not going to isolate in order just to come to a conclusion that is not even justifiable in this regard. What we are saying here, in your worship, is that if you read this paragraph, it's just a misnomer on my part to have said that I also do not know. I do not know. I mean, if no hearing was held for him, how would it be expected of him to know the witnesses? I am correcting this now as we speak to say that these witnesses are actually unknown to him.
Yeah. No, I was just bringing it to your attention. It is evidence that is before me.
Granted, Your Worship, but evidence can be corrected at any given time before judgment.
Yes, thank you.
Yes.
Any other thing you want to bring to my attention?
No. I think I've made out my case.
Thank you.
Thank you.
Mr. Kwenane?
If Your Worship need us to take 5-minute break, I would move that, Your Worship.
You are requesting 5 minutes.
Indeed, Your Worship. Please, is the Worship.
Okay. Let me hear from Mr. Bota.
I will proceed for 5-minute break. Absolutely.
Mr. Mako?
It's now 20 to 1. We break for 5 minutes, which will take us then to 1:15. We proceed for 15 minutes, which take us to lunch, and there will be proposal for lunch. I would rather suggest that we take an earlier lunch. I don't know, I know Mr. Mururi has commitments of taking a child from school at lunch, and